All right, why don't we go ahead and get started? I know there are some people still joining, but good morning and welcome to our webinar today. I'm Lukas Clary. I'm here today with Katie Collins. We're both attorneys in the Labor and Employment Practice Group, and we're going to be talking to you today about pay practices that will keep you out of hot water. There's a better look at us and our contact information as we're going through. So a couple of quick just background stuff before we jump into the material. First, we're going to be moving fairly quickly through the slides today, but we are going to try and leave some time at the end for some Q&A. So if you have questions, feel free to ask them along the way. The way you're going to do that is going to be in the Q&A queue. We don't use the chat feature or the raise hand feature in Zoom for these. We actually put the questions in the Q&A. We may get to them through the course of the webinar as we're speaking, or we may wait till the end, but we'll do our best to try and cover any questions that anyone may have. A couple other things. An e-blast went out shortly before the webinar with a copy of the presentation. So hopefully all of you got that, along with the information on how to get your HRCI or MCLE credits for those of you who are trying to obtain those. If you registered late or late yesterday or this morning and didn't get that e-blast, or if you otherwise haven't seen it, there will be a second one sent out following the presentation with a link to the recording of the webinar. So you'll get that information again. That e-blast will also include links to our Labor and Employment Law blog, which has some valuable information, our COVID-19 resource hub, which is still relevant and something that can be a good resource for those of you navigating those issues. And then information on our California Employment News video series. If anyone's unfamiliar with that, we have a fairly new thing here in the Weintraub Labor and Employment Group where we're doing a series of anywhere from 3 to 8 minute videos discussing some of the day's hot topics in employment law, or some of just the well-established stuff where we give advice on best practices. So you can check all of that as we in our video news series after we get going. So with that, I'm going to go ahead and jump right into the material for today. Katie and I are going to kind of be bouncing back and forth on issues that we're discussing. First thing we're going to talk about is properly classifying employees. So we're going through again the 10 best pay practices to keep you out of hot water, to help you avoid getting sued for employment claims, or if you are sued, to be best positioned to defend against claims of that nature. And pay practices, as we've seen on the litigation side of our practice, are often the mistakes that lead to lawsuits. So it's really important to get these right, because these are the type of lawsuits that are frequently brought as class or representative actions, where an employee files it on behalf of the entire workforce, or at least a significant segment thereof, and they can be lawsuits that carry tremendous exposure. So very critical to get this stuff right. And with that said, the first pay practice I'm going to talk about is properly classifying your employees. So when we're talking about classifying employees, what I mean by that is whether the employee is exempt or non-exempt. The general rule of thumb, the default rule, is that employees are non-exempt. And what does that mean? That means that they are subject to various wage and hour laws, such as the right to overtime when they work a certain amount of hours or days in a row, the right to receive meal and rest breaks, the right to make sure that every hour worked is paid at least minimum wage. These are all rights that most of your workforce should have. There are, however, some exemptions from that. There are some employees that are exempt from that, both under federal and state law. And there are certain requirements that have to be met for an employee to be exempt. One of them is that the employee must be paid on a salary basis, and that salary is not subject to reduction based on the quality or quantity of work performed. So there was a case, almost 10 years ago now, involving insurance adjusters who were paid on a per claim basis. They otherwise met all of the requirements to be exempt from overtime, and I'll talk about the other requirements, but they were not paid on a pure salary basis. So they were non-exempt, and that's an example of a segment of the workforce who was misclassified. That's the word we use in this area. When you think you've got someone exempt from overtime and you classify them as such, and so you're not monitoring hours, you're not paying overtime, you're not providing meal breaks, and it turns out you're wrong and they're misclassified, and that's when you have a lot of exposure for lawsuits. So it's always important when an employer believes that an employee or a segment of the workforce should be classified as exempt, that you go through the full analysis and make sure that they meet the exemption before you start thinking about meal breaks and overtime and all of that. And when you go through that analysis, which I'm going to talk a little bit more about in a second, if you go through the analysis and you realize, I don't think these people meet any of the qualifications to be exempt, then you're going to need to treat them as non-exempt, even if they're making a salary. They may still be non-exempt, and you're going to have to start monitoring hours and providing overtime and the like. Why is that important? I talked about this a little bit ago on why pay practices in general are important, but if you're not monitoring hours because you think someone is exempt from all of this and you're wrong about it, here's what it means. You haven't been given a meal breaks, or at least you don't have any records of the fact that they were taking meal breaks, even if they were. Same thing with rest breaks. You're not monitoring their hours to make sure that you're paying overtime if they go over 8 in a day. You also don't have a way of showing that they didn't go over 8 in a day if they claimed they were, or 40 in a week, or any of the other triggering points for overtime. You don't have a way to counter any claim by an employee that they worked a whole lot more hours than you might believe they did, because you weren't monitoring them if you thought they were exempt. So you're talking about all of these unpaid wages for the overtime, the missed meal breaks and the like. They're going to come with interest. They come with penalties under the labor code, which are usually assigned on a per pay period, per employee basis. So $100 or to $200 per pay period. You multiply that by pay periods going back, usually a year is the statutory penalty period. And then you multiply that by the number of affected employees. And you can see how these numbers can quickly jump into six-figure, seven-figure, if you're a large enough company, even 8-figure territory, where it can really be a crippling thing to go through. And then if an employee has left the company, for all of your employees that left, if they didn't get their overtime or meal breaks, then you haven't paid them all wages that are due. And as most of you may know, there's rules out there that say when someone leaves the company, you have to pay them all wages due at the time that employment relationship ends, whether that is via a resignation with notice or via a termination. If it's a sudden resignation without notice, you get a little extra time, 72 hours, but you still have to pay out everything they earn by the end of the working relationship. So if you haven't monitored hours and you're not doing this stuff, now you're going to be subject to waiting time penalties for these employees as well, which could be up to 30 extra days of pay for every employee who has left the company who is misclassified. On top of all that, if you get sued, you're going to have not only your own attorney's fees to defend a lawsuit, but also the labor code and these statutes that deal with this area of the law say if an employee brings one of these claims successfully, you have to pay their attorney's fees as well. And the attorney's fees can often be the biggest component of liability on claims like this. So it's hugely important to get the exempt versus non-exempt classification correct. There are a series of exemptions available, the most common of which we call the white collar exemptions. And those are the executive management one, which is a managerial exemption, someone who is primarily a supervisor and spending most of their time supervising the workforce and engaged in supervisory tasks such as hiring and firing, scheduling, disciplining, supervising, anything that comes with being in charge of other employees. So that's one exemption that's available. There's an administrative exemption for those who are either assisting the head of the company or a major department thereof, who are engaged in office work, non-manual work of a certain nature. There's an exemption available for certain employees in that category. There's certain professionals, attorneys, doctors, architects, people who have a degree that requires a higher level of education specific to the profession. they may meet a professional exemption from overtime. And there's nuances to each of these, but then there's also one for artistic professionals whose job is primarily to create art or other creative work. Overwhelmingly, the majority of people who meet an exemption from overtime meet one of these white collar exemptions. But there are a few others out there. There are certain computer professionals who meet an exemption. There are salespeople, both outside sales, meaning they're out in the field traveling to make sales somewhere away from their home or their office. And there are inside sales people who are working from the office or from home who are engaged in sales. There are exemptions for both of those. And we do a whole webinar on this exempt issue where we really break down all of these, and it exceeds the scope of what we're going to talk about today. But one thing I do want to mention about the outside and inside sales exception, they're a little bit different, the rules that will apply to each one. And one of the changes we've seen come about from the pandemic is that a lot of people who may have been outside salespeople who may have been traveling a lot to do their job are now doing it remotely, and they may no longer meet the outside sales exemption. You may need to look at whether they meet the inside sales exemption. And then also physicians, doctors, there's a specific exemption for physicians. So you're going to want to look at one or more of these and make sure you meet them anytime you're considering classifying an employee as exempt from overtime and meal breaks and the like. A few key points about all of them is that they all have different standards, different criteria that have to be met in order to classify an employee as exempt. And so one of the most common mistakes I see here is particularly with the white collar ones, because an element of all of those is that the employee must be paid a salary. And one of the common mistakes we see is that a lot of people think that that alone is enough to make someone exempt. Paying salary versus hourly is, excuse me, to a lot of people who aren't familiar with this area of the law, what they think is where the distinction is drawn. And the problem with that is making a salary is just one of multiple. There are 5, 6 elements of each of these tests that all have to be met to make someone exempt from overtime. For example, with the white collar ones, the salary has to be a sufficient minimum amount, which is tied to the state minimum wage. So double the minimum wage for a full-time worker. You take the current minimum wage, say $15 an hour, times it by 2, that's $30 an hour, times a 40-hour work week. That's how much, $1,200, that's how much they have to make in a week to be under their salary to be exempt. Even beyond that minimum, there are other tests. So for example, the managerial one, and I don't have time to get into all of them, but the managerial one, because that's one of the most common ones, they have to supervise at least 2 or more employees. They have to have either authority to hire and fire, or at minimum, make recommendations on hiring and firing that are afforded significant weight in the determination. If that's not part of their job, say, for example, some assistant managers, then they're not going to meet that exemption. They also have to spend, at least here in California, 50% of their working time engaged in exempt duties. So if they're managing employees, supervising, scheduling, disciplining, hiring and firing, all of that, but it's only about 1/3 of their job on any given day or week, and they also spend a lot of time doing the same types of tasks that those employees they're supervising are doing, they're probably not going to be an exempt employee, even though they have management responsibilities and even though they make a salary of that sufficient minimum amount. So, that's just one example, but each of these tests have components like that, and you have to meet them all or the employee will not be exempt. And so I talked about the primarily engaged test a little bit already. That's what I meant by more than 50% of your time. So under federal law, to be exempt under any of these exemptions, it just has to be the kind of core primary aspect of your job is to manage. Say I'm sticking with the managerial exemption. That's enough under federal law, but California can make it tougher to meet the standard, and they do. They say you have to work at least 50% of your time in the exempt tasks to meet the exemption. Also, I mentioned the minimum salary and the fact that they have to make a straight salary already. And when I say they have to make a straight salary, that salary alone has to be enough to hit that minimum threshold. What I mean by that is it's okay if they're also paid another way. Let's say they make a salary, but they also make a commission, or they also get bonuses. That's okay. That the fact that they have another form of pay will not make them non-exempt, but the salary alone has to meet that minimum threshold. You cannot take the commission payments or the bonus pay and count that in to say, yeah, this employee makes enough money to be exempt. They have to make it purely on the salary. So for some best practices there, one, make sure your job descriptions are accurate and that employees in the position are performing those duties. And here's why that's important, because if you get challenged on your practices, on your classification, excuse me, or whether an employee is exempt or non-exempt from overtime and meal breaks, one of the pieces of evidence you're going to be able to point to and look back at is the job description. If you have one that says, here are the duties associated with this job. And if it's a manager, I'm going to stick with that one right now. Supervising, hiring, firing, scheduling, disciplining, all of that stuff. If those are components of the job, you're gonna have nice evidence there. But this is why it's important to make sure that they're actually doing what the job description says. Because if there's a contrast between what's in the job description and what their job actually entails on a day-to-day basis, then it's going to be the actual work that prevails rather than the job description. And there might be a few reasons why what an employee is doing day to day or week to week differs from how the job is described in the job description. One, things could have changed over time, where what they were hired to do may not match perfectly aligned with what they're now doing. Another reason, an employee might just be bad at their job and they're not doing what they're supposed to be doing, and where they're supposed to be spending a lot of time on supervising, they're actually spending a lot of time doing the actual labor similar to the employees they're supervising. And if that's what's going on, they're not going to meet the test. So make sure you have these job descriptions and that you're monitoring the workforce to make sure that they're consistent with the duties that are being performed. If you find variance there, talk to the employees about them. Or if you're unsure what the employees are doing on a day-to-day basis, ask them, talk to them about it, get their input so that you can do the analysis. The Chamber of Commerce and other places, our firm has them too, have worksheets that you can go through to see if an employee meets an exemption. And you can work with employees, talk to them as you're filling out that worksheet, get a sense of what they're doing. And if it turns out they're not doing what is necessary to meet an exemption, then you can consider reclassifying them or making some changes to their job to get them in that exempt territory. A couple other things: implement a policy to review the exempt classifications. There are several times where it can be reviewed. Obviously, at the time of hire, that's important because that's the start of the working relationship. That's as good of a time as any to figure out what are we hiring someone to do, what are the expectations that they're going to do, all of that. But also, if an employee transfers jobs or has their duties reassigned in some way, that could happen for a number of reasons. It could happen due to changing needs of the business. It could happen as an accommodation of a disability, which is a whole nother topic that we can talk about on a different day. But anytime something happens that changes the employee's job, that's a good time to review this and make sure, are they still exempt, or do we have to reclassify them? Or maybe they weren't exempt and now they are, and we can get away from all of this hour monitoring. That's as good a time as any. If you don't have a change like that in the employee's workforce, I still recommend an annual review, or at worst every 2 years or so, just to make sure that things haven't changed in what the employee is doing to take them out of that exempt category. And the ways that are most likely to fluctuate getting them in and out of that territory is either if their salary, they don't get a raise and the minimum wage goes up. We've had that happen a lot in the last few years is when the minimum wage is rising. It's meant that the minimum salary threshold is also rising to make someone exempt. And if you don't adjust, that could take them out of it. Or changes in their duties mean they previously have been spending over 50% of their time on exempt tasks and they no longer are, or vice versa. That's when we see this stuff change. So it's important to monitor it, at least every year or two. So that's tip one on exempt, non-exempt classifications. Tip two, which actually is related to that, but even outside of that, is paying the correct minimum wage. So if someone is non-exempt, they have to make minimum wage for all hours worked. That's common sense. We all know there's a minimum wage. We're all aware of it. And that's the easy part. What's not so easy is tracking all of the changes that that have been going on, over the last few years. So whereas just as recently as 3 or 4 years ago, minimum wage was, $11, $12 an hour, depending on your workforce. Now we're up to $15 an hour if you have at least 26 employees, $14 an hour for smaller employers, but they will also be at 15 January 1 of next year. And what we just hit very recently, you see that bottom part of this slide, rate adjusted annually for inflation. So there's when the statute was passed to make minimum wage slowly creep up to $15 an hour, it built in a mechanism beyond the 15 to monitor inflation. And if the metrics were hit to trigger a rise, that $15 an hour was no longer enough under this formula, it could go up more. And we just learned a few days ago, actually, some of you may have heard, some of you may have not, that metric has been hit. And as of January 1 of 2023, minimum wage is going to go up to $15.50 an hour. So it's still going up, and that's going to affect your non-exempt employees if you're paying at or around minimum wage, and it's going to affect your exempt employees if their salary needs to rise to continue to meet the exemption. Also on minimum wage, keep in mind that there are a lot of local cities and counties, communities that have gone higher above the state minimum wage. So the way minimum wage, and really the way all of labor and employment law works when you're talking about federal government, state government, and local government, is federal government sets the floor of employee protections. So sticking with minimum wage as the example, there's a federal minimum wage that is lower than $15 an hour. I don't even remember what it currently is because I am a California attorney, and the lower federal minimum wage doesn't really affect the advice I give, but there's a lower one. States cannot take away from that floor of protection that the federal government sets out there. They can only tack on additional employee protections. So they have raised the minimum wage. They've said $15 an hour at the state level here in California. And that same dichotomy exists between the state government and local governments, where local governments cannot go below the floor of employee protections that the state and federal government have placed. They can only tack on additional ones, and some communities have. So for example, a lot of them in the Bay Area and the LA area, Emeryville, Berkeley, San Francisco, I believe Los Angeles, they all have enacted minimum wages that may be higher than the $15 an hour current statewide minimum wage. We have a full breakdown of what the minimum wage is by year. There's a link you can go to get those, and you'll see, depending on where your workforce is, this is how much we have to pay. One last point on this, and then I'm gonna turn it over to Katie to go with the third tip. That those local minimum wages do not impact the minimum salary for exempt employees. That is specifically tied to the state minimum wage. So when I said earlier that an exempt salary has to be double the minimum wage for a full-time worker, that's the state minimum wage. And even if they're in a local city or county that has a higher minimum wage, that's not impacted. So now I'm going to turn it over to Katie, and she's going to talk to you about a few more tips.
Good morning, everyone. As Lucas indicated, my name is Katie Collins. I'm an associate in the Labor and Employment Department. And I am going to talk to you about tips 3 through 5 and then switch it back to Lucas. Tip 3, I think, is one of the most important. Ensuring thorough and accurate time records are kept for all non-exempt employees. A lot of times the lawsuits that are filed, particularly these PAGA lawsuits where we're talking about potentially millions of dollars in penalties, the first thing that we're going to look at to refute these claims that the other side are making are time records. And when employers have kept thorough and accurate time records with employees signing off on their accuracy, with audits taking place, ensuring that everything is properly kept, they are covering themselves in every way possible and make it a lot easier to defend against these type of lawsuits. So pay close attention. I'm just going to give you some tips in terms of what process you can implement to make sure that your time recording is proper. So as hopefully we all know at this point, time record requirements require that you keep a record of when an employee clocks in and out for their shift, but also when they clock in and out for a meal period, as well as a record of any split shift intervals, and then obviously a tally of the total hours worked each day. Rest periods, so while meal periods are clocked in and out, for those rest periods, the 10 to 15 minutes that you're providing employees twice in an 8-hour shift, those are not required to be recorded. So those are on the clock breaks or being paid. So obviously off duty, but on the clock breaks that are not recorded in your time records. Non-exempt employees should record their own time. So people should not be recording time for others. Every non-exempt employee should record their own time and sign off as to the accuracy of what they record. So I know a lot of times now, most everyone is doing it electronically in some sort of app or some sort of electronic platform where an employee can sign on at the beginning of their workday on the computer to record their own time. Some people also use time clocks or time punch systems where someone is actually punching in and out a time record. Regardless, it's important that every employee be trained how to properly engage in using whatever system your workforce uses, so that they can make sure that they are diligent and accurate in their recording of time. So lawsuits obviously come about when time is not being recorded at all, obviously, when time is not being recorded properly. And like I said before, the penalties are a lot harder to refute when we don't have accurate time records that took place in real time to rely on. So different steps of time and attendance verification. Step 1, employee review. An employee should review their own time. Hopefully they're punching in and out, clocking in and out, doing whatever they're doing to record their time in real time. But after doing so, they should be reviewing their own time and verifying its accuracy. So maybe one day they forgot to clock in until 10 minutes after they were already working there and then clocked in later. They need to be able to be provided the opportunity to realize, oh, that day doesn't reflect the accurate time worked because I actually didn't clock in until 10 minutes later. I got busy doing something and didn't realize what time it was. The employee needs that step to show that they've reviewed their time, to correct any and all inaccuracies, to have discussions with supervisors, payroll management, whoever they're coming to with the inaccuracies, so that those are corrected before the end of the pay period. The sooner you can correct any errors, the better, and the less risk of later penalties. So this obviously provides an opportunity to correct errors properly. It makes sure that we can properly code time off. So if employees are calling out during the week and it gets coded sick, but then we realize they actually were using vacation time, or it gets getting coded as some sort of a leave, but it actually was supposed to be sick or vacation. However it may come about, the employee can look at their time record and verify and make sure that it was kept properly, that their time is being deducted properly if we're talking about sick and vacation accruals, and that everything is a true representation of what happened that week, what hours they truly worked, what hours they took off, and what the reasoning for that was. This avoids over and underpayment. So, and I'll talk about it a little bit more on the next slide, but we obviously want to avoid any off the clock work. So when an employee has a chance to look at their time cards and ensure that it represents every minute of every hour that they were working, that provides us with a second step of assurance in making sure that it's true and accurate. So errors otherwise go unnoticed until end of employment or worse, which is when those penalties start to accrue and we face lawsuits. Step 2, supervisor review. So not only should employees be reviewing their own time cards and ensuring their accuracy, a supervisor should also be reviewing the employee's signed time cards. This is a training opportunity to ensure, if you have an employee that's consistently forgetting to clock in until 10 minutes after they've started their workday, or forgetting to clock out at the end of the day, forgetting to clock out for a meal period, anything of that nature, reviewing the time cards at the end of the week or at the end of the pay period, however you choose to do it, will help the supervisors provide that training to their employees about proper timekeeping. A lot of times employees can view this as more of an annoyance. Why does it matter that I failed to clock in until 10 minutes after the fact? It's not a big deal, some things of that nature. Staying on top of employees as the supervisor and management level can help you ensure that employees are understanding the severity of this issue. Proper timekeeping is so important to not open the company up to liability, and it needs to be enforced at every level. And supervisors reviewing those time cards is going to provide that opportunity for that discussion with the employees. And then the supervisors can also verify whether a missed short late lunch was a choice or true business reason. So when a supervisor is looking over time cards, they're obviously going to notate whether a compliant break was taken. Like I said before, rest breaks are not recorded on time records, but meal breaks are. Supervisors should be trained to know what a compliant versus a non-compliant meal break is. And to the extent those time records that they're reviewing show non-compliant breaks, that's a discussion they should be having with the employees in real time when they're reviewing these records. What happened on this day? Did you get too busy? Were you distracted? Were you having a personal conversation? Did you forget to clock out? And find the reasoning and get that confirmed in writing. That will help immensely when we're talking about whether premiums should be paid out in certain situations. And then later on, if claims are brought up, oh, I didn't get a meal period on this day because I got busy with a project or because I was asked to stay on duty for 20 more minutes, whatever it was. If we then refer back to, actually, we have in writing here that you discussed with your supervisor and you signed off on the fact that you were having a personal conversation and forgot to clock out for lunch, even though you had already stepped away and were having your own personal lunchtime. Things of that nature where we can writing, that's kind of a end all be all for all attorneys. Write everything down when it comes to documenting employee reasons for not doing things, or employee reasons for missing punches or late punches. It should always be documented and signed by the employee if at all possible. This also provides supervisors the opportunity to confirm overtime. So reviewing an employee's time record it's going to be very clear, who's working overtime, to what extent they're working overtime, whether such overtime was authorized. This will then provide the supervisors an opportunity to discipline if necessary for any violations of policy. So obviously you have to pay the employees for whatever time they worked. But if you have an employee that's not authorized to work overtime and is recording 10 overtime hours every week or something of that nature, that's good. You're going to want to refer to your employee handbook and discipline an employee if they're violating the policy. Discipline does not mean don't pay them for the time. Discipline means pay them for the time that they accurately reflected on the time record, and then move forward in your discussions with that employee from there. So very, very important tip. Managers must be trained not to ask employees to fix or change an accurate time card that reflects a missed meal or overtime, but rather discipline if appropriate. So this is what I was talking about before. We can absolutely discipline an employee if they are taking a late lunch 5 days a week because of things that are not due to being short-staffed or not being relieved of duty, but because of their own doing, that they're forgetting what time it is or something of that nature, not business related, and they're missing a meal 5 days a week and incurring meal period premiums because of it. That's a conversation that should be had and discipline should be imposed. But managers and supervisors should not be telling employees, oh, I see that you did this, let's just bump it back so that it's before the 5th hour. That is not appropriate. That should not be happening. I think a lot of times there's confusion at the management level because they hear from the company, we don't want to deal with all these premiums. We're getting so many premiums. People are taking late lunches. People are missing their lunches, whatever it may be. And so they feel that pressure. They understand, okay, goal is not pay a bunch of premiums, but that does not affect the fact that they cannot change accurate time cards. So they have to keep the time cards as is if it's an accurate reflection of the hours worked, of the fact that they missed a meal or the meal was late or whatever overtime they worked. But they should implement moving forward more training with their employees, discipline if appropriate with employees, to ensure that those things are fixed in the future and that employees aren't working a bunch of unauthorized overtime, that they're not missing their meals unless some sort of emergency or short staff issue comes up, things of that nature. So it's crucial that management understands you cannot change the time records to make it look like something happened that didn't happen, but you should take the opportunity to review so that you can work with your staff and work with your employees on ensuring that you're not dealing with these meal premiums or with an exorbitant amount of overtime moving forward. Step 3, payroll review. So the last step, so we have kind of several levels of review here. The last step is that it's going to go to payroll. The timekeeping system should be set up, if possible, to trigger premium pay for any missed, short, or delayed meal periods. So a lot of people use very different, and some people use ADP. We've got people using Kronos, many different payroll systems. Almost all of them have a way to set up an automatic premium payment, to where if an employee clocks out for their meal period after the 5th hour work, or miss a meal period, or clocks a meal period that's anything short of 30 minutes, an automatic meal premium will be paid. That's something where people are really covering themselves and ensuring that any time record that is showing a non-compliant meal period, even though the employee may have done it on their own, there may be some other reason they weren't prevented from taking that compliant meal period, paying the premium ensures that we have done away with that liability. And then payroll personnel can ensure premiums are paid by reviewing the time records, that proper rates of pay are implemented, that supervisors and employees are staying in line with the policies. So when a supervisor is reviewing the time cards and they're notating down that they've had a conversation with an employee about excessive overtime or whatever might be happening, the payroll level of review ensures that they can make sure every step has happened. The employee has reviewed it, the supervisor has reviewed it, everyone is staying compliant, everyone is trying to move forward and correct whatever issues have happened moving forward, and everyone is headed in the right direction. So tip number 4, prohibiting off the clock work. I know I kind of touched on this already. And in California in particular, we don't apply the federal de minimis rule. So in federal law, there's something called de minimis, which essentially means it's such a small, minuscule amount of time that it doesn't really matter and we don't need to be worried about it. That is not applied by California state courts. Employers in California are required to pay their employees a minimum wage for all hours worked. And that's defined as the time during which an employee is subject to the control of an employer, and includes all the time the employee is suffered and permitted to work, whether or not required to do so. So this is an important thing to keep in mind. I know most of us, luckily we're kind of on the other side of COVID. I know cases have kicked up lately, but back in March 2020, most all of us started doing some sort of a COVID screening that was being required at the onset of the shifts. And hopefully employees were clocking in before doing such screenings, but this is an issue that's coming up more and more. And it's similar to time spent where people are having to undergo searches. So whether you work at a retail store, whatever employer might be requiring this, a time spent on an employer's premises waiting for and undergoing required exit searches of packages, bags, or personal technology devices voluntarily brought to work purely for personal convenience by employees is compensable as hours worked. So this is an important case that came out several years ago, where I think it was a Starbucks case actually, but if an employee is required to undergo some sort of a step where they're under the control of the employer, it's required for them to be able to work that day in terms of undergoing this search so that they can go on to the next process, undergoing a COVID screening so that they can enter the workplace and begin their shift, whatever it may be, that's considered hours worked, and we must be paying employees for all hours worked. So whether time is compensable depends on a number of factors: the mandatory nature of the activity, the location of the activity, the degree of the employer's control, whether the activity primarily benefits the employee or employer, and whether the activity is enforced through disciplinary measures. So when looking at most COVID screenings, those were mandatory. Employers were requiring them, temperature screenings, sometimes filling out a questionnaire. The location was at the employer's premises. You were under the control of the employer at the time. Most were. It obviously dependent on how the screenings were being conducted. And the activity is benefiting the employer in the fact that they're ensuring that their clients or whoever is at the workforce is protected from the ongoing pandemic. So for any type of on-the-clock work or off-the-clock work that you may be requiring at present, whether that's screenings at the beginning of the workday, whether that's exit searches and entrance searches, you need to look at these factors and figure out whether it's going to require that you pay employees for that time. And I would say more often than not, it is going to require that they be paid. Okay, and on to tip number 5, never round employee time. This is becoming more and more common of an issue in light of some recent case law. That back in 2012, in the See's Candy Shops case, the rule in California was that an employer is entitled to use a nearest 10th rounding policy if the rounding policy is fair and neutral on its face, and it is used in such a manner that will not result over a period of time in failure to compensate the employees clearly for all the time they've actually worked. So the focus is on an impacted workforce as a whole rather than individual employees. So if an employer is implementing a rounding policy, they would then have to look at the policy's implementation and whether the employees overall, looking at the entire workforce, whether they were being paid less due to the rounding or whether they were being paid more due to the rounding. And if the workforce as a whole was being paid however much, so, thousands of minutes less, a couple hundred minutes less, whatever it may be, if it is to the detriment of the employees, then it is not okay. And the Donahue case was the recent California Supreme Court case last year that came out that held that rounding may not be applied to meal periods. So even if you have a rounding system in place pursuant to the last case as your clock in and clock out times for your shift, when it comes to meal periods, rounding cannot be implemented. We have to meet exactly that 30 minutes as required by the labor code when we're talking about a meal period. So a big part of what was happening when we talk about rounding is that maybe someone was working or someone was off the clock for a lunch period and it was a 28 or 29 minute lunch, but the rounding system that was in place in that timekeeping system rounded them up to 30 minutes to make it look like a compliant meal break. That under the labor code is not in fact a true 30-minute meal break. And that's why in the Donahue case, they held that that was not allowed. So review policies and consider eliminating all rounding policies that you may be doing in your workforce. I think, especially in light of Donahue and the fact that we're dealing with this clear understanding that it cannot be allowed for meal periods, you're going to want to do away with the confusion of maybe having it for other things, but not having it for meal periods. That seems like an added step of complication that is going to create potential risk there. So our advice is to just eliminate all rounding altogether, keep true and accurate times down to the minute of when the employee is clocking in and out for the shift, when the employee is clocking in and out for the meal period, so that it's a true representation of the time worked and also the time that an employee is spending off the clock for a meal period. And with that, I'm going to switch it back over to Lucas.
Thanks, Katie. So that's the first 5 tips. We are now at just about the halfway point and moving into tip number 6, providing wage statements that reflect all required information. So we're talking about the information that goes to the employee with their paycheck or at the time that they receive paychecks every 2 weeks or twice a month. as it may be. Why is this tip so important that you provide accurate, compliant wage statements? There's a body of law called PAGA, stands for the Private Attorney General Act. Most of you may already be familiar with that. I guarantee you, if you've gone through a PAGA lawsuit as a workforce, you will never forget the word PAGA, because they are such crippling lawsuits, and they, more than any other area of the law, they arise in the context of wage statement violations and issues. So what, just really briefly, what PAGA is, it's a body of law that allows employees as private attorney generals to step into the shoes of the government and enforce the California Labor Code on behalf of the entire impacted workforce, all aggrieved employees. And the Labor Code carries with it penalties for all sorts of violations, including for violations of Labor Code section 226, which, as I move to the next slide, requires various things to be on the wage statement every time it comes out. There are 9 sub-bullet pointed things there that have to be on every wage statement. So first of all, it's got to list the gross wages. How much total before taxes did the employee receive during that pay period? It's got to list the total hours worked if it's a non-exempt employee. Obviously, with exempt employees, presuming, going back to the beginning, that they're properly classified, we don't have to monitor their hours, so there's no requirement there for them to have total hours worked. But for non-exempt employees, you do. And then if they're paid in another way, like with piece rates, so if they get paid based on a certain productivity measure, you see piece rate pay, for example, in the auto mechanic industry. You fix X number of cars, you complete X number of jobs this day, each one pays this amount. You see it in the transportation industry. Truck drivers often get paid on piece rates based on mileage covered, things like that. If you're paying them in a piece rate manner, you've got to list on the pay stub how many piece rate units they've earned, how many what you take the applicable piece rate, whatever that is, and then the amount that it's going to be multiplied by, that has to be on the paycheck. And then any deductions from it, so the tax, Social Security, anything that's withheld from the check has to be reflected on the pay stub. That gets you to the net wages earned, how much they made after the deductions. And then you get into the kind of the more what I call nuanced, seemingly less important aspects of the pay stub, but for PAGA purposes, equally as important, the inclusive dates of the pay period. So if it's May 1 to 15, that's got to be reflected in the pay period. If it's at every 2 weeks, May 1 to 14, that's got to be reflected. And then the employee's name and an identification number, which commonly is and can be the last 4 digits of their Social Security number. It doesn't have to be the last 4 digits of the Social Security number. If you have an independent ID number that you use as a workforce to identify employees, that can be on there as well. But most commonly it's the last 4, but only the last 4. You never want to put the full Social Security number on there for privacy and other reasons, even though presumably they should be the only one who sees their pay stub. Don't put the entire Social Security on there. That would be a violation. It's just the last 4. And then here's where it gets kind of crazy. The name and address of the legal entity that is the employer. And so if you're a DBA, if you have, if you go to the Secretary of State website and there's a name of the corporation or LLC that's the employer, but that's not what you're commonly known as a business. You have a trade name that you're known as, or a DBA. You got to have that legal name on there, not the DBA, and the address. Both of those have to be on there. And then all hourly rates in effect during the pay period and the corresponding number of hours worked under each rate. So for example, if they work 40 regular hours and 15 overtime hours, both the regular rate and the overtime rate and the number of hours have to be on there. Occasionally you get employees who make different regular hourly rates based on the type of task they're doing. For example, some employers may pay less for travel time than for on the job time when they're at the location. If you have multiple rates, they all have to be on there. And if you get any of these wrong, I like to use the name and address of the employer because to me that's the craziest one. If it says a DBA instead of the legal entity of the employer, what's the harm to the employee? They still have all of the information about what they got paid and why and all of that. They certainly didn't get paid anything less. They got paid presumably the correct amount. But if that legal name is not on there, that's a PAGA violation, which if you've got it wrong on one pay stub, you probably got it wrong on all of them. So it's going to affect the entire workforce, and you're going to have a $100 to $200 penalty per employee per pay period, going back a year from when the claim is resolved, carrying forward to when you either correct the problem or the lawsuit, if you're on the wrong end of litigation, is resolved. And this is when I was saying earlier, it can be 6, 7, 8-figure numbers for not having the name and address right. You know, it's crazy, but that is PAGA law. So get this right. Make sure if you work with a payroll provider, make sure you're connecting with them to guarantee that all of this information is properly on a pay stub. If you're not 100% sure that you have this right, go look at some pay stubs, at some wage statements, and make sure it's all on there. Another little nugget about wage statements, and well, actually, before I move on to that, here's an example of what it should look like. So this is a sample pay stub. So you see on there at the top, there'll be a company name and address right there at the top. It doesn't have to be at the top. This is just an example of where it is, but that's on there. And then you see, toward the upper right, SSN, the first 5 numbers are X'd out, but you got those last 4 as that identifying number. Moving down to right above the box, you have the inclusive pay period. You would also have the employee's name on there, which I actually don't see on this one. So you're going to need the employee's name on there as well. And then moving into the box, you see the gross rate, you see the deductions, you see all hourly rates in effect toward the left and how many they worked, with total numbers down near the bottom. All of this needs to be on there to have a compliant wage statement. Before I move on, just one other little nugget about this is you're required to maintain these records for a period of 3 years, and I actually recommend maintaining them for 4 years because that's how far plaintiffs' lawyers can make these lawsuits potentially reach back if they shape them the correct way. And if an employee requests records, their pay records, you have 21 days to provide them to the employee, or it's a $750 penalty. So just a couple other little nuggets about wage statements. PTO and paid sick leave. So if you provide PTO, and everybody has to provide paid sick leave, right? If you provide these things, you need to make employees aware of them at the time that the pay stub is issued. So the PTO or vacation, that actually needs to be on the pay stub or in a separate writing, a separate document that is provided at the same time as the pay stub. So on that same designated pay date, you have to be constantly letting employees know how much PTO, vacation, or sick leave they have available to them. And if it's an accrual method, which both vacation and sick leave can be accrued over time, that's kind of a constantly growing number and then reduce when they use it. So that number could be changing a lot, and you have to always at the time of the pay period make sure they're aware of it and that you're updating them with it. So even if you have all 9 of those things that I showed under the Labor Code section 226 that are required, this is a separate obligation here that corresponds with the wage statements. Okay, that's 6. Moving on to tip number 7, properly calculating the regular rate of pay. What is the regular rate of pay? The regular rate of pay is the amount that you have to pay employees either when they take sick leave or when you have to pay them that extra hour of pay for missing a meal and rest break, or it's the amount you're using to calculate overtime. So when you get into the territory where you have to pay time and a half, you're paying time and a half of the regular rate of pay. To getting into double time, if they've worked more than 12 hours in a day, you're paying double the regular rate of pay. So what does that term mean, the regular rate? there's a common tendency to just think of the hourly rate if an employee is making, is paid by the hour, or if an employee is salaried but not exempt, because as I said earlier in the presentation, some salaried employees still may not meet an exemption. Then with a salaried employee, you would take 1/40th of the salary for their hourly rate, their regular rate. That's the start of the analysis, the base hourly rate or 1/40th of the salary rate. But there are other things, if they make money in other ways, there are other things that have to be factored into that regular rate of pay. So I've talked a little bit about piecework earnings. If they get paid on a piece rate, in addition to an hourly rate of pay, that also has to be factored into the regular rate of pay. Objective production bonuses. And what I mean by that is we're not talking about a purely discretionary, you did a good job, we're going to give you a year, end of the year bonus because we feel like rewarding you. It's when there's something like a component, it's similar to piece rate actually. If you hit this sales number, you're going to get this bonus. If you make X number of widgets, you're going to be eligible for this bonus, or anything like that, where they know if I do X, bonus Y in Y amount is going to be paid to me. That's an objective bonus, and the law says that has to be factored into the regular rate of pay. Same thing with commissions. If your employees earn commissions, that factors into the regular rate of pay. And then some things, some lesser things that you might not even think about, like meal benefits. If you provide paid meals to the employee, or housing, or a stipend to be available on call. These are things that under the law have to be included in the regular rate of pay when you're calculating overtime or when you're paying out sick pay or meal and rest breaks. And I'll explain a little bit more in a second what that means, but before I get there, let me talk a little bit about some things that you don't have to include. So I mentioned discretionary bonuses. So if there's no way for the employee to know, I do X to achieve this bonus, it's just something the employer decides to do in an amount that the employer chooses to give with no obligation and no promise to do so, that's a discretionary bonus. You don't have to factor that into the regular rate of pay. Any gifts, like a Christmas gift, if you give out gifts at a year-end holiday party or something, that doesn't have to be included during the regular rate of pay, as part of the regular rate of pay. When you pay them work for when you pay them when they don't actually perform work, so vacation, holiday, and sick pay. So I mentioned earlier, the amount that you pay for those things is paid at the regular rate, but that money isn't factored into the regular rate. So you don't have to tack that on when you're calculating the regular rate. Also, if you provide extra payments for failure to provide a meal and rest break, that 1 hour of premium, again, paid out at the regular rate, but the amount of that doesn't go into the calculation for determining what the regular rate is. Contributions to benefit plans. So if you have a 401k match or something like that, that doesn't factor into the regular rate of pay. The overtime compensation, the extra amount, that doesn't factor in. It's just the what you're paying them for their regular hours. And then premium pay. So shift differentials, you see this in some industries. The hospitality industry might be a common one, where someone comes on for the lunch rush and then they're off for a few hours and then they're back for the dinner rush later. If you have split shifts where they work more than where they have a break of more than an hour or less, it's considered a meal break. But if it's over an hour, if it's more than an hour long between the two shifts in the same 24-hour workday, you pay an extra split shift premium there, but that doesn't have to factor into the regular rate of pay. So these things you can move out, but things in the prior slide do have to be factored in. The way that works, before I get a little bit into weighted average, the way that works, an example of how that works, let's say somebody works 40 hours at $20 an hour, that's $800, but they also in that same week made an extra $200 in an objective bonus, that because they hit some metric. So they actually made $1,000 during that week in their straight 40-hour time and the bonus. So 1,000 divided by 40 is 25, even though their base hourly rate is $20 an hour. You're paying, if they hit overtime in that week, you're paying time and a half or double on that $25 an hour. Same thing if they take a sick day or a vacation day that week, or if they miss a meal break. Now, the weighted average. So if you have two different rates of pay paid during the work week, and I mentioned earlier some times where that may happen if someone gets travel time at a different rate, or if they kind of work two different jobs and they get paid X amount of an hour for their management type of job, and Y amount, a little less an hour when they're doing more just general basic work. Anytime you have someone making two different rates, the way that you have to do it for figuring out regular rate of pay under California law is you have to come up with this weighted average. So you take all hours worked in the week and you divide it by the total compensation under the two rates, and you get that combined number to come up with the weighted average. So you see an example there. Let's say someone works 52 hours, which would entitle them to 12 hours of overtime that week, right? 40 of them at 15, there's your $600. And then you're paying travel time less. So they work 12 hours at 13, that's 156. So that you take that 756, you divide it by 52, that's how you get that weighted average. 1454 becomes the regular rate. And for their overtime, you pay time and a half on that, okay? Now, prevailing wage, if any of you are in the field where prevailing wage is paid, and this is public works jobs, you see it in the contracting industry a lot when you're doing work that the government is paying for. There's a whole body of law on public works and prevailing wages that say workers in this classification need to be paid this amount for the work they do. If you're in that field, if you're in that space, then when you do this weighted average thing, just know that you have to pay the higher either the weighted average or the prevailing wage for that work or for those hours worked. You can't use a weighted average to get below the prevailing wage. So I already mentioned this, but the reason that I want to hit it again on overtime, sick leave, and meal and rest periods is because these ones are often overlooked. More employers are aware, even employers who already have an understanding of regular rate of pay and how that impacts overtime, more employers are aware of the overtime component side of it and don't always think about it with the overtime, sick leave, and meal and rest periods, particularly meal and rest breaks. And the reason is there's actually been a change in the law within the last year or so where a California Supreme Court case came out where the issue was, do meal and rest breaks have to be paid at that base hourly rate or at the regular rate of pay like overtime and sick pay is paid at? The prevailing viewpoint up until this case came out, the way almost all employers were doing it and the way most employment lawyers were advising on it was for that meal and rest period premium, that extra hour of pay when you miss that break, you only have to pay it at the base hourly rate. But this California Supreme Court opinion said, no, that's not right. You actually have to pay these at the regular rate of pay as well. So that's a fairly new development. So even if you have decent command of regular rate of pay issues, if you haven't been paying meal and rest breaks at that regular rate of pay, make sure you're doing that. Okay, moving on to tip number 8, reimbursing for business expenses. So under California law, employees are entitled to be reimbursed for all reasonable and necessary business expenses that they incur. It's Labor Code section 2802. If it's something that they have to go out and spend money on and it's necessary to do the job, the employee cannot be asked to bear the burden of that expense. It doesn't matter if the employee's making enough above minimum wage that they're still paid minimum wage, even if they're asked to incur those expenses. It doesn't matter if the employee's making a $500,000 a year salary, they're still entitled to be reimbursed. The employer must incur the burden of business expenses. And so there are two kinds of components here. Mandatory, they have to be mandatory. If it's something that is not necessary to do the job and the employee just goes out and says, you know what, I think this will make the job easier for me. I want to use this tool or this equipment or this software to do the job. And the employer says, well, you don't need to use that. You can do it this way. This is the way, this way is okay. And they choose to do it. That's not a mandatory expense. It's not a necessary expense. You don't have to reimburse it. The other component is that it should be reasonable, right? So if an employee has to travel for work, that doesn't necessarily entitle them to go buy a first-class ticket to fly across the globe to Europe to do the job, or to stay in some five-star hotel at $1,000 a night if the employer thinks that another hotel would have served just fine. It has to be reasonable as well. So necessary and reasonable. If you hit those two components, employee must be reimbursed for it. There's another development in recent years that has really made business reimbursement expenses go from sort of one of the duller, less often litigated issues of employment law to becoming a hotter topic with more uncertainty. And there's this little thing that's happened in the last couple of years. You may or may not have been aware. We had this thing called COVID, this global pandemic, right? And everybody started working from home. And so that impacted a whole lot of areas of employment law. And in other seminars and presentations, we'll talk about some other areas that have been impacted by COVID. But in the world of business expenses, you start to ask what that an employee is using at home is a necessary business expense. If they go and purchase a desk, is that a necessary business expense? Maybe not. Maybe they didn't need a desk to do the work at home. But I can tell you, personally, as someone who, before the COVID pandemic, working from home for me meant popping up my laptop on the kitchen table, whereas I through the pandemic, shifted to dedicating a full room with my dual monitors and my desk and everything, replicating my office working environment. And as someone who's gone through that experience, I might be open to the argument that the desk and the monitors, that actually was necessary for me to do my job properly. But it's a gray area, so it's something that you should be thinking about and looking at with any employees who you may have still working from home, because there may be at least an argument that you have to reimburse for some of that. One key component there, though, remember, going back to necessary, you have to ask, is it actually necessary for them to work remotely? So early in the pandemic, a lot of workforces mandated that, and some of it was not even the employer choice, it was through government restrictions, mandated that everyone go work from home. You cannot come to the office. You have to do the job at home. In that case, there's a lot stronger argument for employees that what they use at home became a necessary business expense. Whereas now, you might still have some employees who are choosing to work from home and you're allowing it, but you're not requiring it. In that situation, make sure that you're letting them know we're not requiring you to work from home. If you're choosing to, the business expenses, your desk, your computer, you're choosing to create that environment, but we provide that for you in the office and you have the ability to come do it here. Then you might not have to reimburse for it. Some best practices on reimbursement policies. One, it's a good idea to provide the employees with all equipment you deem necessary, because that could be a laptop, it could be a cell phone, it could be, if they're an employee, that tools are part of the job, provide them the tools, because then you have a lot more control over how much the equipment should cost, what equipment they should use, and you don't have to worry about them going out and buying things and then you have to pay for it even if you may not have thought it was necessary. Just go ahead and provide them the stuff if you have that ability. There are some downsides to that approach. If employees depart and they don't give it back, it can be difficult as an employer to go out and chase that equipment back or the value of it. You can't deduct it from the paycheck or anything. So there are some drawbacks to that approach as opposed to having them buy it and reimbursing them. But I still think it's a better approach. We still advise that if it's something you're easily able to do, go ahead and provide that equipment. Also have a policy that clearly outlines which expenses are reimbursable and to what extent, and make clear to the employees that if they incur necessary business expenses beyond those anticipated, that they should get advanced approval, that they should make sure you're okay with that. Now, if an employee goes out and buys something without getting advanced approval, and you have a policy requiring them to get advanced approval, that's not going to be a basis to deny reimbursement if it still qualifies as reasonable and necessary. You still have to reimburse for it. Your recourse there, it's similar to what Katie talked about earlier when an employee isn't doing what they're supposed to do with time records. Your recourse is to discipline. You can, counsel an employee, talk to them, suspend them, demote them, terminate them, whatever you think is necessary to discipline them. But what you cannot do is say, you didn't get advanced approval, which we required, so we're not going to reimburse you for this expense. You cannot do that. With that, I'm going to turn it back to Katie, and she's going to talk about providing compliant meal and rest periods.
Hello. So I know we touched on this a little bit earlier in the sections I was talking about. So I may be a little redundant here, but it's only because this is crucial to ensuring you don't get hit with one of those PAGA lawsuits like Lukas was talking about. So tip number 9, providing compliant meal and rest periods. There we go. So meal periods, a meal period of not less than 30 minutes. So going back to that rounding issue, it has to be at least 30 minutes on the dot, no less. For an employee working more than 5 hours. If the work is completed in 6 hours, a meal period may be waived by mutual consent. The second 30-minute meal period is required if the work period is going to be more than 10 hours. Unless an employee is relieved of all duty during that 30-minute meal period, it shall be considered an on-duty meal period and counted as time worked. On-duty meal periods are only permitted if the nature of work prevents an employee from being relieved of all duty and when parties agree in written agreement. And the employee is allowed to revoke this agreement at any time. So some important points here. 1, you can have meal periods or meal waivers in place. So if you consistently have employees that are working 6 hours or less, I would recommend instituting those meal waivers, offering them to employees to sign should they wish to do so. That just provides, most employees want to sign them. If you're only working 6 hours, most employees don't want to have to clock out for that 30 minutes and miss that 30 minutes of pay that they could be getting for a relatively shorter shift. When it comes to on-duty meal agreements, those should only be used when they are necessary. We should not be implementing on-duty meal agreements when you have multiple people working shifts and it's just inconvenient to take a meal period, but not impossible to take an off-duty meal period. So convenience versus possibility is an important distinction here. When we're talking about an overnight security guard, so let's say an individual is responsible for overseeing a building. He's the only individual that's in the building at the time. He has to constantly be monitoring the security screens that are in front of him. He cannot walk away from the desk or cannot stay away from his radio for a full off-duty meal period. That's a situation where you're going to want to institute an on-duty meal agreement, saying we understand that you're not able to clock out for a 30-minute period where you would be completely relieved of all duty because we require you to keep your radio on, to be responsive to calls, to recognize that there's a security risk to the building, but you will remain on duty, and here's the agreement to that effect. So those are the specific situations where you can use that type of agreement. The employee should be paid for that 30 minutes, obviously, because they're not clocking in and out as an employee would typically do. And an employee should also be provided the opportunity to actually eat their lunch. So if that security individual is working, let's say an 8-hour shift, we can't say that he can never be provided the opportunity to eat his lunch or to look at his phone for a minute or whatever he may want to do at his break. It just means that he can't be fully relieved of duty. So he should still be provided the opportunity to eat a meal at his desk or wherever he may be allowed to do so. These on-duty meal periods, I think the biggest confusion that comes up with them is that they're sometimes put in place more of a convenience. Because we want to keep clients coming in and out. We understand we're all busy, we have things going on, but they should really only be instituted when they're absolutely necessary given the nature of the work. So something to look at. We don't want to just institute them, employee-wide and make assumptions. We want every person's job to really be reviewed to see how many people they currently work with in a shift. If they are the only person on site, what kind of job responsibilities they have. Do they have to be responsive to a radio? Do they have to be responsive to an individual that has special needs and they cannot walk away? looking at the nature of work and spelling out why this person has to be subject to an on-duty meal agreement is crucial. And even when an on-duty meal agreement is in place, if there's a time, so say that when we're talking about the security guard, say sometimes he works alone, but other days he's scheduled to work a shift with another security guard, and they take turns holding the radio and responding to calls and looking at the monitors, or however that may go down. He may be able to clock out for a 30-minute meal period, and he should be provided the opportunity to do so if there's another individual that can hold the radio during that shift and provide him that opportunity to be actually off duty for the full 30 minutes. And the duty to provide meal periods. So this is an important distinction. Employers need only provide employees with the opportunity to take meal periods. So this obligation is satisfied if the employee is relieved of all duty, the employer relinquishes control over activities and permits the employee a reasonable opportunity to take an uninterrupted 30-minute break. So if the employee is not impeding if the employer is not impeding or discouraging an employee from taking a meal period, relieves them of duty, says you can do whatever you want, this is your 30 minutes, you're off duty, take your meal period as you wish, that is meeting the employer obligation. Meal period timing, this is a crucial thing. It has to take place before the end of the before the end of the 5th hour of work. So often we see, especially when we're talking about the rounding, so this is another issue that came up with the rounding, where someone would be 5 hours and 10 minutes into a shift and then clock out for a meal period. Well, that's not compliant per California law. They should be clocking out for that meal period prior to the 5th hour of work. And the Brinker case clarified that employers are not required to provide a meal period for every 5 hours of work, the rolling 5-hour argument. So no extra lunches for employees who take lunch early. So say an employee is working a 10-hour shift, they are only required to take 2 lunches. So, or even an 8-hour shift, I guess. If an employee takes their first lunch at the 3-hour mark or the 2-hour mark, let's say they take their lunch at a 2-hour mark, they're not then entitled to another lunch because more time has passed before they have to clock out for the day. So it doesn't matter if you take it early, it doesn't mean you get more lunches. The important part is to not take it late. Rest periods. Duty to provide rest periods. The term major fraction thereof as applied to a 4-hour period to mean any amount of time in excess of 2 hours. So anytime in excess of 2 hours, an employee is entitled to a total of 10 minutes rest for shifts from 3.5 to 6 hours in length, 20 minutes for shifts of more than 6 hours up to 10 hours, 30 minutes for shifts of more than 10 hours up to 14 hours, and so on. Employees are permitted to take rest periods in the middle of each work period insofar as practicable. So the requirement as to the specific timing of the rest period is not as critical as the meal period timing. It's just supposed to be insofar as practical in the middle of each of the 4-hour work periods. In the context of an 8-hour shift, one rest break should generally fall on either side of the meal break. So you would take that meal break before the 5th hour of work. You would take a rest break at the beginning, towards the 2 hours into your shift likely, and then another rest break 2 hours before you left for the day. Employers must provide rest breaks at the rate of 10 consecutive minutes for each 4 hours or major portion thereof, worked as near as possible to the middle of the work period. These are paid breaks. So like we talked about earlier on, these are not breaks that the employee is clocking in and out for. They're not off the clock for these breaks. These breaks are paid. And rest breaks may not be combined into one 20-minute break. So the rest break has to be provided for every 4 hours or major portion thereof. We can't just combine the 20 for an 8-hour shift and call it a day. And rest breaks cannot be added to meal breaks, even at an employee's request. So we're not going to be using, let's say an employee typically gets a 30-minute lunch and 2 10-minute rest breaks for an 8-hour shift. We're not going to just cut the rest breaks and say, okay, you can have a 50-minute lunch break because we'll just call it your lunch break plus your 2 rest breaks. That is not allowed. And employees cannot use breaks to start late or end early. So the important part is it's supposed to be somewhere in the middle of the work period to the extent possible. It should not be happening at the very, very end of a work period or at the very, very beginning of a work period. And our last tip, tip 10, providing employees with a way to easily report any non-compliant meal and or rest periods. And this kind of goes off of what I had talked about before when we're talking about the proper timekeeping records and the different steps of review. So we had employee review, supervisor review, and then payroll level review. This is an extra step that we recommend to ensure that we can double check the reasoning for why a non-compliant break is being shown on a time record. So I know we talked earlier about automatic premiums being paid in your timekeeping system to make sure that anytime a time record shows a non-compliant break, a premium is paid and liability for that is cut off. However, we recommend an additional layer of review, let's call it, to discuss with the employee to figure out what is going on, what happened here. Is this was this caused by business needs? Was this caused by short staffing? Whatever it may be, or was this a personal choice? Was this something where you're just not paying attention to the clock, or you were having a personal conversation, or you chose to take it late and it was voluntary, no one impeded your ability to do so? So California law provides that employers must pay 1 additional hour of pay at the employee's regular rate of pay for each day a meal and or rest period is missed. So this is what Lukas was talking about when he was discussing regular rate of pay earlier. The premiums should be paid at the regular rate of pay, not the base hourly rate. So that's an important distinction to keep in mind. The premiums are due no later than the next paycheck after the non-compliant meal and a rest break takes place. And then California Supreme Court has characterized the extra hour of pay as a wage, not a penalty. This is significant because we're now talking about a statute of limitations of 3 years rather than one year. So when we're talking about PAGA cases, when we're talking about class actions, the penalties are exorbitant for claims of this nature. And meal break attestations. So something that came, the Donahue case, which I mentioned earlier, specifically brought about an electronic attestation that was being used by this company, AMN Services LLC. And that case, the Donahue case, held that employers can use these electronic attestations to track meal break violations or to establish that an employee was provided a meal break but voluntarily chose to continue to work. So here, a drop-down menu was prompted where the employee was to choose one of the 3 options. I was provided an opportunity to take a 30-minute break before the end of my 5th hour of work, but chose not to. So there, that's the employee's voluntary choice. They were not impeded from doing so. Number 2, I was provided an opportunity to take a 30-minute break before the end of my 5th hour of work, but chose to take a shorter or later break. So here we're talking about a time record that shows them taking, let's say, a 29-minute break or a 20-minute break, or beginning a break after that 5th hour of work, but they did so voluntarily. It was not due to anything that the employer did. So voluntary, no premium would be owed. Number 3, I was not provided an opportunity to take a 30-minute meal break before the end of my 5th hour of work. Number 3, a premium payment would be owed because they're saying they were not provided the opportunity, and we know the employer has the obligation to provide such opportunity. So that is when the premium payment comes into play. This attestation really provides for that explanation step that we were talking about with the supervisor review of time cards. The conversation here, it's not a conversation as much as checking a box, but it requires an employee to take additional steps to say, I understand my time record shows a non-compliant meal break, whether that means it was short, whether that means it was late or missed completely. And my time card shows that because I either voluntarily didn't take it, took it late, took a short break, or my employer actually prevented me from doing so. Whether that was because we were short-staffed that day and I was in the middle of something, whether I got asked to perform more work and couldn't clock out on time for a meal break, whatever that might be. And when it's the employer that causes the employee to not take a compliant meal break, that premium payment must be made. So attestations shift burden of proof back to the plaintiff or back to the employee to establish that they did not have an opportunity to take a meal or rest break, even if time records show they did not clock out for a compliant meal break. So here, if we have a record of every time the employee missed a break or took a late or short break, they voluntarily chose to check this box or to click the drop down that said that their choice, that their decision to do so was voluntary and was not by anything the employer did. That's something we can then rely on if this were to go to a lawsuit or to a class action, to a PAGA action, to say, we understand that the time records reflect non-compliant meal breaks, but for those non-compliant meal breaks, the employee told us that it was their voluntary choice to miss their meal break altogether, to take a short break or to take a late break. We relied on that information from the employee, and that's why a premium wasn't paid in those instances. And some employers also use meal and rest period premium request forms. So this is just another good recommendation in terms of documentation. And it basically requires any employee who is not authorized and permitted to take a meal period and or rest period, which complies with California law, as we talked about before, is required to fill out this form and basically do the same thing that the attestation was doing, in saying that I understand I took a late meal period, I took a short meal period, I missed my meal period. It was because I chose to do so voluntarily, or it was because we were short-staffed and I was required to stay on duty even though I was prepared and ready to clock out for my meal period. Then the reasoning, the form is submitted, reviewed by a supervisor, obviously reviewed by payroll, and they're paid a premium in response to anything that might have been caused by the employer versus a voluntary choice of the employee. So in implementing these attestations, these extra steps of forms can really shift the burden of proof back to the plaintiff or back to the employee when we're talking about potential lawsuits down the road, and show that we took every step to ensure that any non-compliance we sought reasoning for, and we have documentary evidence that employees signed or that employees authorized in some way, saying that their choice to have a non-compliant meal period or rest period was in fact a voluntary choice and was not forced upon them by the employer. Okay, and with that, we have some time for questions. I know we have quite a few here.
Yeah, a number of them.
So we can just move through them.
Yeah, I think we'll just take them in order we receive them, and if anybody has any more as we're going through them, feel free to get them in now, and we'll try to get to yours if we have time as well. First question we were asked was, can an 8-person vet clinic get a waiver for having to provide the mandatory 30-minute unpaid lunch break? So the answer, the classic lawyer answer is it depends, right? And it would depend. Probably not. And we would need a lot more specific information to advise on the specifics of this particular vet clinic. But generally speaking, there is something called an on-duty meal period where someone actually doesn't take a lunch break, off the clock, where they're relieved of all duties. They still are there, have to do their duties, get paid for the time, but is not a violation where the meal period is owed. But in order to have a compliant on-duty meal period, 2 things need to be in place. One, the employer and the employee have to agree to it. That's the easy part. Second, the nature of the job has to be such that relieving the employee of all duties for 30 minutes and having them off the clock, not working, is just not practical, and wouldn't work for that particular job. That is one of the most difficult standards to meet legally. I've had a number of clients say, I think that's me, and here's why. Really, it's talking about circumstances where maybe there's only a single employee working, and to give that employee a break, and you would have to shut the place down, or there's a security risk or something like that. It's really tough to meet. There is even the California Labor Commissioner, they will occasionally release opinion letters where people will write to them and say, tell us what you think on this scenario, and they'll weigh in, here's what we think, and they publish that, and it's not binding law, but it's authority for all of us to look at and consider. And there was one where someone wrote and said, we have only 2 employees working at a time. One is a manager. This was a restaurant of some sort. We have a manager up front and a cook in the back. We can't relieve the manager of all duties because then there's nobody up front who's in charge, who's a manager, who can handle management decisions with customers and stuff like that. And the labor commissioner said, we don't think that's good enough. We think you can train that cook in the back to, at least for 30 minutes a shift, be able to handle potential management issues that might come up, and relieve that other person of all duties for 30 minutes. That can be done without disrupting your business operations too much. So that's how tough the standard is. So yes, there is a meal break, on-duty meal break option, but it's very tough to meet. And if you're even considering it, I would strongly recommend working with legal counsel to get an opinion on whether it's going to work under your facts.
And I think there's an important distinction. What I touched on before is the convenience versus necessity, right? Like Lukas said, the labor commissioner is going to take a pretty stringent approach here, and pure convenience, the fact that it's inconvenient for us to schedule however many people to take a meal break, isn't going to be enough. There has to be a necessity for why the individual would have to stay on duty,
right? Given
the nature of work.
Yeah. The next question, I think I actually answered this one during the webinar, probably came in before I addressed it, but the question was, has the new increase in minimum wage in California been confirmed that it's going up to $15.50 in 2023? Yes, it has, and it will be. So you'll need to make adjustments based on that. Next question, what should an employer do in reclassifying an employee from exempt to non-exempt to reduce the chance the employee will claim the employee was previously misclassified? So this is one of the trickiest areas, right? You go through that exempt, non-exempt analysis that I was talking about earlier. You realize this person, we've been treating them as exempt. We shouldn't have been. So we'll switch it. We don't want to be out of compliance. So we'll switch it. We'll call them non-exempt now. We'll start monitoring their hours, paying overtime, giving meal breaks, all of that. But what do we do about the time period we got wrong? So as Katie and I both talked about litigation and lawsuits at various points during this presentation, we mentioned there are statutory look-back periods. It can be anywhere from 1 year for certain types of labor code penalties to 3 years for unpaid wages. And I mentioned earlier, sometimes they can even go back 4 years if the plaintiff's attorney representing the employee pleads it correctly. There's an area of the law where they can get it to go back 4 years. So what do you do about that period? You have a few options. One, you can go back and do the best you can to figure out how much you underpaid or mispaid, pay it moving forward. Pay it backwards so that, they've at least now been made whole. It might not get you off the hook for the penalties and interest unless you also pay that as well. And hope that paying it reduces the likelihood that anyone's going to raise the issue. Another option is you can roll the dice that it doesn't happen, and you wait out those statutory periods, 1 to 4 years of waiting and hoping nothing happens. If you're inclined to go that way of not correcting the mistakes moving back, you're rolling the dice. That's what you're doing. But one thing I've suggested before is see if you can come up with an explanation for why you're changing it moving forward that stops short of telling an employee, we realize we got this wrong. We were misclassifying you. We were significantly underpaying you. And so we're going to correct it moving forward. Maybe don't tell them all of that. Maybe, we've been looking at our business operations as a whole. This is a move the company is making. Maybe you even make some changes to their job duties that could allow you to at least try to argue that you were okay before, but because of these changes, now we're going to treat you as non-exempt. We don't want to go with the raised salary that may be necessary because of the minimum wage increase. Some explanation that stops short of acknowledging that you got it wrong there is what I recommend. Okay. Next question. I have an employee who regularly doesn't fill out the detail of their hours, only the total. We then pay her what we reasonably believe she worked. What can we do? She is not an on-site employee. So I know, Katie, you talked about tips around timekeeping. Do you want to weigh in on it?
Yeah, I can definitely take that one. So one, obviously, conversation should be had with this employee. So we were talking about the multiple levels of review, the employer review, supervisor review, and a supervisor that's reviewing a time card that is largely incomplete and not doesn't contain all of the required information. I assume you're talking about a hard copy, actual handwritten in time card, given how this is phrased. Given that, a supervisor should be having conversations with the employee. If discipline is appropriate and instituting some sort of discipline in response to this, getting the employee to properly fill out these time cards. It's not okay to just be including like 8 hours, in 8 hours in a column. In order to provide more extensive advice, obviously we'd have to know what the format of time records you're using, why your employees are using handwritten time cards, whether there's an option for her to do something electronic, even if she is offsite. That those kind of things would have to be looked at to make it, maybe more potentially convenient for her. What is her reasoning for not providing hours? Is there something impeding her ability to actually record in real time the hours that she's working? All of those kind of questions come to mind and would have to be worked through in relation to this specific employee. But mostly that supervisor review and discipline. I think obviously we hope that everyone's employee handbook requires timekeeping in the format that we talked about throughout, clocking in and out for a shift, clocking in and out for a meal period, per the labor code. And that any employee that's not complying with that is not complying with your policies and with California law. So working through that process with her, figuring out why she isn't filling it out correctly, why she's not complying with company policy, and what you can do to help her fix that moving forward would be my suggestion. And Lucas, I think we skipped over one question. It looks like someone said, and 26 or more employees include your total workforce, not just California workforce. I think that one goes to the spreadsheet for the minimum wage, whether it was 26 and up or not.
Right, yes. And so the answer is it only applies to your California employees in terms of who you have to pay the minimum wage to. You don't have to meet the minimum wage for your out-of-state employees, but they do count for determining your total workforce and whether your California employees are entitled to minimum wage. And that's generally speaking true in almost all areas of employment law here in California. I don't want to say all because I think there are some exceptions, although none are coming to my mind. But for example, there are minimum employee thresholds with leave of absence laws and disability accommodation laws and all these things. And the standard is the same for all of that, where the employees who work outside of California, they don't have the rights and the protections that the law offers, but they are counted for determining whether you meet the employee threshold.
And then the next one is kind of a two-part question. It looks like there will be the slides will be provided in e-blast following this presentation, I believe. Is that correct, Lucas?
Yes.
Yeah, so the slides, so I know we have a couple questions throughout that ask about slides, and e-blast will be provided to you following the presentation. And then this person also asks, we have an employee that regularly doesn't fill, oh, wait, is that the one we already did?
That's the one we covered, yeah.
It's a second, okay, so it's just repeated question, my apologies. Is it okay to enforce the 30-minute time for a meal period by locking the time clock to not accept a less than 30-minute punch? So this is something that I have seen various employers do. I think, and I saw a follow-up, Jennifer, down below. She says, to clarify the above, the employee is locked out of being able to punch back in and may have to stand and wait to badge in. So the important part is that they're being provided the opportunity to take that full 30 minutes. So there's something called walking time that comes up from time to time, depending on where your time clock is or where your timekeeping system is. You don't want to, if you're imposing discipline, if they're a minute over 30 minutes, and that's why they're standing at that time clock because it took them 5 minutes or however long to walk to wherever they need to punch in and out, and they're then standing there waiting to clock back in until it hits the 30 minutes so that they don't get in trouble for going over the 30 minutes, then that's a problem. And that's something that you're not truly providing them the 30 minutes off duty. If, on the other hand, the system, maybe they work at a computer, they sat down at minute 29 and they can't clock back in until 30, I don't see an issue with that in that situation. I think it just depends on what kind of workforce you have, where the person is clocking in and out, whether they're being disciplined or told that they can't go a minute over 30 minutes, which would require them to sit down and spend some of the time that they were supposed to be off duty on a lunch, then waiting there to clock in to ensure that they don't get disciplined as a result. I think it really depends on the specific circumstances of the workforce.
Yeah, and then the other thing I would add to that is, it's fine in theory to have the system set up to where they can't clock back in early, and I think the intent behind that, is to show you haven't taken your full 30 minutes yet. We don't want you working yet. Finish your 30-minute break, and then you can clock back in, and that's well intended. There could be a risk, though. You need to make sure there's a way, if you have a system like that, that you're also ensuring they're not doing any work. So using Katie's example of someone who works in front of a computer, if the software they use to clock back in isn't available until that 30-minute mark, probably the software they use to do any work shouldn't be available during that time either, because otherwise you're going to have situations where an employee says, "Oh, I came back, started working at 25 minutes. I just didn't clock back in because I wasn't allowed to yet." So there, not only did I not get a fully compliant meal period, but I also was doing off the clock work. And so we've got layers of violations there and issues. So really make sure if you have a system like that, that you have a way of ensuring they're not actually doing any work, that is not just preventing them from clocking in.
Right.
Okay, next question is, do they have to receive the wage statement on paper, or can they be electronic? As a multi-part question. So let me start with that one. They can be electronic. You can have, a portal. A lot of employers do. In fact, my firm has a portal where employees can go in every payday and log in and access their pay stub. You don't have to actually physically mail a hard copy to them, as long as you're making it available in a way that they have access to and can see it. Now, that being said, if it's only available online on a portal, you have to make sure that an employee has the ability to, even when they're not in the office, access that and see it. Now, second part of that question was, and with the quote, "You have used X hours of California COVID pay." So this is getting back to the requirement that sick pay, even the which we still have, at least until September 30th, COVID specific sick pay that employees have available to them. The requirement that also has to be either on the pay stub or included in the information. The question is, does that have to be mailed USPS, or can it be delivered via email? Because the employees in this circumstance are all working off site. So again, same answer. It doesn't have to be a physical mailed copy, as long as there's a way that they can access it anytime they want. Okay, the next question is, if employees receive their pay through direct deposit, what is the requirement for the employer to provide the pay stub? So that's kind of a similar question to what I just answered. That's okay to pay them through direct deposit. You still have to, on the regular payday, whether it's twice a month, biweekly, whatever it is, on the regular payday, you have to make that wage statement available to them, either by handing them a copy, mailing them a copy, or making it available electronically in a way that they can access it.
And I think the next question is similar to what you just said too. I believe it relates to pay stubs. Says, what about California sick pay hours available? And as Lucas said, you just have to make it available to them.
Yeah, okay. Does the overtime rate not count as an hourly rate that needs to show on the pay stub? So this is getting back to the tip around compliant pay stubs. Yes, it does. So if they work overtime, they need to be able to see, let's say someone worked 50 hours, 40 hours at straight time, 10 hours of overtime. The pay stub needs to reflect that. I'm going to use a round number, 40 hours at $20 an hour The extra $10, 10 hours was time and a half. So it's got to show on there 10 hours worked at $30 an hour. At minimum, there's got to be enough information on the pay stub where anyone can look at it and do simple math and figure it out. But the best practice is to actually lay it out. Here's your overtime hours and your overtime rate.
And to total the hours, like Lucas said, there is case law out there that if simple math is all, if all it would take is simple math to get to the total hours worked, then maybe you don't have to have a specific listing of the total hours worked. However, this has continued. I don't know if this has been the case for you too, Lucas, but in the last few cases that I've taken to mediation in particular, this is something that's highly disputed, this concept of total hours worked and whether it truly is simple math when you might have a column that says regular hours, a column that says overtime hours, but then you've also got other categories, premium hours, sick hours, and those aren't actually truly hours worked because they're in fact premium payments, sick hours. So an addition of all of those hours in that column isn't actually going to result in the total hours worked. That's something that's in dispute and we think is going to be assessed by the Supreme Court in the coming years. Just in what we've been seeing going on. So something to pay attention to is you may want to, just out of an abundance of caution, rather than requiring simple math, actually list on the pay stub the total hours truly worked in a pay period.
Yeah, I completely agree with all that. I mean, to me, it's why even put yourself in a position where you have to make the argument that you could do the math and figure it out. Why not just make it as express as possible?
Right.
You know, you're not putting yourself out there with that potential risk.
Absolutely. So do COBRA payments need to show on a pay stub? Is what the next question says. I assume that means after if someone is terminated, if you are still under the obligation to provide them a pay stub reflecting COBRA payments. And no, that's once someone is terminated, their final paycheck should be the last time that you provide them a pay stub. Absent some other, if the final paycheck didn't include all wages and you had to do some sort of a additional pay later on, that's the only reason I could see issuing someone a pay stub after termination.
Yeah. Okay, no, and I agree with all that. Next question is, our workday is midnight to midnight, but we have 3 to 5 offsite employees who work 10 p.m. to 6 a.m. Can we change the workday to be 9 p.m. to 9 p.m. for that work location? Otherwise, don't we have a 16-hour split shift? So the answer is yes, you can make that type of change. And yes, if you don't make that type of change, you may have a split shift premium issue that you're creating. So the way it works under the law is a work day. When anywhere that the law is talking about a 24-hour workday, it's any 24-hour period that is designated by the employer. It does not have to be midnight to midnight or 12:01 to midnight. It doesn't have to be exactly Monday and then exactly Tuesday. You can have a different 24-hour period with a few caveats to that. You have to expressly designate it as such, whether it's in your handbook or a standalone policy. The employees have to know that this is what we consider our workday. And 2, it has to be something that is done as a consistent business practice, why it works for this job and this location, et cetera. I mean, again, we talk hypothetically when we answer these questions. We're not giving specific advice to a specific person, but hypothetically, those facts just presented in that question, there's probably a legitimate business reason why you've got people working graveyard shifts. You want to define your work week differently on a consistent basis. What you can't do is kind of move it around for this specific employee this week. We changed it this week, next week it's this, then the following week it's that, or for this employee it's this. It can't be seen as an attempt to circumvent split shift laws or whatever law it is that you might be in trouble with if you have a Monday to Monday, Tuesday to Tuesday work. It can't be construed as like strategically trying to get around it on a case-by-case basis. It's got to be, a fairly consistent approach for that work job and location over time. All right.
And the next one, I believe, was Jennifer the clarify the above, we already touched on with the employees clocking in right at the 30-minute mark. And then we have a question, are internet costs part of the reimbursements? Did you want to chat about that since you had
Sure.
talked about reimbursements?
Yeah, so it's another, it depends. They might be. So again, going back to when I was talking about reimbursements, are they working remotely because they have to? The employer requires them to either work from home or, travel and do the job in various locations where they need to, be places where they have Wi-Fi access. If the employer is requiring it, then yes, the internet costs are part of a necessary business expense and they need to be reimbursed if using the internet is necessary to do the job. By contrast, if you're not requiring them to work from home, or there's nothing about the job that requires them to have remote internet access, and they're choosing to do their job that way, then you probably don't have to reimburse for it. But in that circumstance, even if you think you're in the latter circumstance, make sure that's clearly communicated to the employee, whether it's a written policy on, here's how we reimburse remote work, here's what we do and don't cover, or in response to a specific question from an employee, make sure you're explaining to them why we don't cover this so they know.
And the next question, during an on-duty meal period, would employers still be required to pay premium pay? So here we're talking about those specific situations, the security guard who has to stay on duty all night and entered into an on-duty meal agreement. No, you would not pay a meal period premium for the meal period. However, the fact that they're having to remain on duty for the meal period means that they're likely remaining on duty for the rest periods that they're taking during their shift. And as you'll recall, a rest period has to be off duty. They have to be relieved of all duty to be able to walk away from their radio, from the screens that they're monitoring, whatever it may be in that specific instance, which then requires a rest period premium to be owed. So for those on-duty meal agreements, no, you don't have to pay a meal period premium, but you do need to pay one rest period premium for each shift where an employee is unable to be off duty for those rest breaks per the fact that they're the nature of the work performed.
Right. Okay, the next question, I think this is very similar to the first question. And so I think we've already answered it, but was if you have a small medical office that makes it difficult to allow uninterrupted meal periods, can it be waived if employee voluntarily wishes to waive their lunch? So that goes back to that same thing that Katie hit during the presentation, and then we answered in the very first question. There's a chance that you might qualify for one of those on-duty meal periods where you say the nature of the work precludes it. Probably not. It'd have to be a pretty small medical office. Certainly if there's only one employee and it has to stay open and you can't close for lunch, yes, but good chance that it's not. But talk to counsel if you want more specific advice about that.
Next question. So are you saying you do not pay a meal period violation for employee choice? So just to go back to that attestation and the different voluntary versus employer, prohibiting them from taking that fully compliant meal period. No, you do not have to pay a meal period premium if it is abundantly clear, meaning the employee is attesting to the fact that their choice to take a late, short, or miss a meal period altogether was completely voluntary, that the employer provided them the opportunity to take a compliant meal period, did not impede them from doing so, didn't require they perform any work during the time, but that it was their voluntary choice to either take that late, short, or missed meal period, then no, you do not have to pay premium. But I would just, out of an abundance of caution, make sure that you are documenting and that you have something signed by the employee saying that it was in fact voluntary. Because when we get to a lawsuit stage or when we get down the road, it's going to be he said, she said, if you don't have something in documentation with signature attached to it. The employee, might turn around later on and say, no, they were trying to, it wasn't truly voluntary because the employee just told me, why don't you just never take your lunch, or why don't you not take your breaks? And where I'm not requiring to you, however it might be phrased, it has to actually truly be the employee's choice and truly be voluntary, not just the employer trying to say, oh, it's more convenient for you or more convenient for me if you could just work straight through. That's not voluntary. So fully understanding what it means to be voluntary and that the fact that the employer's obligations has been met, and then ensuring that you have that documentation piece.
So next question is, please explain what we do about the calculation of regular rate of pay when a qualifying bonus is only calculated quarterly. So that's a great question. That's something I should have hit actually when I was talking about it. So again, now we're talking about one of those bonuses that does qualify because it's an objective productivity based or metric based bonus where they know if they hit something, they're entitled to it. So that factors into the regular rate of pay for paying overtime and sick pay, but we only pay this quarterly. So how do we know during the previous 2, 3, 4, 5, 6 pay periods when they were working overtime, how do we know how much to add on? So what you do here, you don't have to guess at it and try and figure it out along the way. What you do is once the bonus payment comes in, that is the pay period that triggers your obligation to now do the calculation and go back during that quarter, figure out how it would have impacted the rate of pay and pay the extra amounts during that next pay period. So you don't have to figure it out along the way.
The next one, if the staff voted for 4 10-hour days, do they still have to take a meal period before the 5th hour? And here, Mr. Nelson is talking about an alternative work week schedule that's been implemented. Yes, that doesn't change the obligation to have the meal period before the 5th hour worked.
Right. Okay, and then the question, what is the difference between bonus and a spiff? So a spiff is like in the sales world, an incentive payment. Essentially, a spiff is a form of bonus. It can also, if under certain circumstances, be considered a commission, but both an objective bonus and a commission are calculated in the regular rate of pay. So for the purposes of that world of what we were talking about, they're one and the same. A spiff is factored into regular rate of pay calculation. I think that's all of our questions, and we actually timed it fairly well because we're right about at the end here. Just in these last couple of minutes real quick, you've got a few more slides here that show, well, first, this is, I mentioned this at the beginning, our short video series of 3 to 7 minute videos. It's usually 2 of us here in the group discussing some of these legal issues. You can access that through our L&E law blog or on our YouTube channel. Be sure to check those out. That's, quick, valuable little nuggets that kind of take either points of these larger seminars or other best practices and kind of hit them concisely. And then we've got, a few more upcoming ones. I won't talk through them. You'll get the PowerPoint, but we've got sexual harassment prevention training coming up. We'll talk more about accommodations and leaves on August 17th. What do you do when someone's ending the relationship, firing or voluntarily? We'll talk about that in September. And then, just developments, get you up to speed on what's progressed over the year by November. So with that ends our seminar. As mentioned in the beginning, you will get another email after this with information, with the slide decks, our contact information, should you have any follow-up questions. And I think that's it. So thank you for your time today, and we'll see you next time.
And thank you all for asking such good questions. I think they helped the conversation flow here at the end. So we always appreciate the questions.
Absolutely.
Thank you. Bye.